In this Right to Property and Constitutional Amendment video series, I have spoken right from the first constitutional amendment and the various landmark judgments of the Supreme Court which led to the first constitutional amendment. As several judgments of the Supreme Court led to several various constitutional amendments, and various constitutional amendments led to various landmark judgments of the Supreme Court. Now, in order to understand these videos, the First Amendment deals with the insertion of Article 31A and 31B to the Constitution. Now, these articles were inserted because of the judgment of the Patna High Court in the matter of Kameshwar Singh versus State of Bihar, wherein the Bihar Land Reforms Act of 1950 came to be declared as ultra-vires the Constitution by the Patna High Court on the grounds of violation of Article 14 of the Constitution. Now, the Bihar Land Reforms Act was the first act in the country in order to abolish the zamindari system and provide for redistribution of land to the peasants and the farmers. This was a very important socio-economic reforms of the government of that day, and they wanted to implement it in a fast-track manner. But this judgment of the Patna High Court was coming in the way of implementing the socio-economic reforms within the state of Bihar. Also, the state of Uttar Pradesh had enacted its Land Reforms Act, which was again challenged by certain zamindars before the Uttar Pradesh High Court. And the Uttar Pradesh High Court issued an injunction against the implementation of the said act. Now, it is because of this judgment and also various judgments of the Supreme Court in its first year of functioning, like Romesh Thapar, Brij Bhushan, Chintaman Rao, Champakam Dorai Rajan, which led to the amendment to the Constitution. And the Constitution was amended by inserting various provisions under the Part 3 of the Constitution. In fact, the President at that time objected to the said amendments, saying that it is an irony of fate that the first amendment to the Constitution amends the Part 3, that is fundamental rights of the Constitution. Now, this insertion of Article 31B created a ninth schedule under the Constitution, wherein laws could be placed and they would become immune from judicial review, and the courts would not be in a position to declare them to be ultra-vires even if they violated fundamental rights. So it created a safety vault where laws could be parked and they would become immune from judicial review. Now, this was certainly a very drastic constitutional amendment. So without waiting for the judgment of the Supreme Court in the appeal preferred by the state of Bihar challenging the Patna High Court decision in the matter of Kameshwar Singh versus state of Bihar, the Provisional Parliament amended the Constitution by inserting the first constitutional amendment and creating this Article 31A and 31B to the Constitution. Now, this amendment was challenged by certain zamindars before the Supreme Court by preferring a petition under Article 32 of the Constitution for enforcement of their fundamental rights, and they alleged that the constitutional amendment violated their fundamental rights, and to that extent it should be declared to be invalid. It also alleged that the Provisional Parliament could not amend the Constitution, as the provision under the Constitution under Article 368 provides that the bill for amendment of the Constitution has to be placed before both the houses, and only after clearance from both the houses the said amendment can take place, and the Provisional Parliament did not have the power to amend the Constitution. Now, this challenge before the Supreme Court failed in the year 1952 when the Supreme Court delivered the judgment in the matter of Shankari Prasad Singh BO versus Union of India, rejecting the petition and upholding the constitutional validity of the first amendment to the Constitution. So, with the failure of the first petition challenging the first constitutional amendment, Article 31A and 31B remained in the Constitution, despite of affecting the basic structure of the Constitution. After the Shankari Prasad Singh judgment upholding the validity of the first constitutional amendment, the major landmark judgment of the Supreme Court was in the matter of state of Bihar versus Kameshwar Singh, the Maharaja the Raja of Darbhanga. Now, the appeal of the state of Bihar, which challenged the judgment of the Patna High Court declaring the Bihar Land Reforms Act of 1950, came up before the Supreme Court. Now, by that time, the amendment to the Constitution had already taken place, and the validity of the First Amendment had already been upheld by the Supreme Court. Now, the First Amendment also placed the Bihar Land Reforms Act of 1950 under the ninth schedule of the Constitution. So therefore making it immune from judicial review under Article 31B, and it got the protection that the courts could not declare the said act to be void on the ground of violation of fundamental rights. Now the judgment of Kameshwar Singh is a very important judgment of that time, is because despite of the validity of the first constitutional amendment being upheld in the judgment of Shankari Prasad, and also placing the Bihar Land Reforms Act under the ninth schedule, the Supreme Court in the said matter declared certain parts of the Bihar Land Reforms Act to be unconstitutional on the ground that it was a fraud on the Constitution. Now, for the first time, even 20 years before the Supreme Court laying down the basic structure doctrine, the Supreme Court held that if any part of an act is a fraud on the Constitution, then despite of the said act being placed under ninth schedule, it could be declared to be ultra vires by the Supreme Court, and therefore creating this ground for declaring an act even if placed under the ninth schedule made this judgment a landmark judgment of that time. Now, after the judgment of Kameshwar Singh, the major landmark development in the constitutional law was in the judgment of State of West Bengal versus Bela Banerjee, which also I have dealt with in my earlier video in detail, and I will be going to speak about it in a very brief manner. When the Land Reforms Act of West Bengal came to be challenged before the Calcutta High Court, and the Calcutta High Court declared the validity of the said act to be ultra vires, and this matter reached the Supreme Court, and the Supreme Court also laid down that the said act was ultra vires the Constitution on the ground that it did not provide for an accurate compensation to the persons whose properties were appropriated. And this led to the fourth constitutional amendment in the year 1955, which provided that the courts could not enter into the validity of an act on the ground that it did not provide for an appropriate compensation to the persons whose properties were acquired or expropriated. So therefore this created another hurdle before the Supreme Court in order to examine the validity of the act on the ground that the compensation was not properly provided. Now again, this was a drastic constitutional amendment because it took away the power of judicial review. And if the Supreme Court at that time had laid down the principle of basic structure, the Parliament would not be in a position to lay down such constitutional amendments. But as the basic structure doctrine was not there at that time, the Parliament kept on amending the Constitution, thereby taking away the power of judicial review in order to examine the validity of certain acts. And the Parliament kept on amending the Constitution and placing several acts with regards to land reforms under the ninth schedule. After the fourth constitutional amendment, several state legislatures kept on enacting state laws with regards to land reforms and abolition of zamindari system. And the said laws were challenged by the zamindars or persons whose lands were acquired before the High Court and the Supreme Court. And the Supreme Court from 1955 to 1964 in several landmark judgments declared several of these laws to be ultra vires, or several provisions of these acts to be ultra vires the Constitution on the ground of violation of fundamental rights. Now all these judgments where the Supreme Court declared these laws to be invalid, the Parliament amended the Constitution by way of the 17th Constitutional Amendment and placed all these acts under the 9th schedule of the Constitution, thereby revalidating all those acts and provisions which were declared to be ultra vires by the Constitution. Now this was again a drastic constitutional amendment because the acts which have been declared to be ultra vires, which violate fundamental rights of the citizens, are saved and placed under the 9th schedule and are revalidated and implemented despite of the judgment of the Supreme Court. So therefore several judgments of the Supreme Court came to be nullified or not given effect to because of these constitutional amendments which placed these acts under the 9th schedule. So therefore the 17th constitutional amendment, which placed several acts of the state legislature under the 9th schedule, came to be challenged before the Supreme Court in the matter of Sajjan Singh versus Union of India. And the Supreme Court again examined the validity of the constitutional amendment. The Supreme Court upheld the validity of the 17th constitutional amendment and also held that the Parliament has the power to amend any part of the Constitution, and there are no restrictions with regards to this power of amending the Constitution And it also held that the judgment of Shankari Prasad Singh Dio does not require to be reconsidered by a larger bench. But the judgment of Sajjan Singh is important is because of the minority view taken by Justice Hidayatullah and Justice Mudolkar. They questioned the correctness of the judgment of Shankari Prasad and also held that the parliament did not have the power to amend any part of the constitution or create such constitutional amendments which take away the essential features of the constitution. Now, because of this minority opinion of Justice Hidayatullah and Justice Mudolkar, they questioned the correctness of this majority view, and this led to another judgment of the Supreme Court in the matter of L.C. Golaknath versus State of Punjab, which had also challenged the 17th constitutional amendment. It is because of this minority view in Sajjan Singh that the Supreme Court constituted a bench of 11 judges to examine this very important question with regards to constitutional law. The Supreme Court in the judgment of L.C. Golaknath, by a majority of 6:5 judges, held that the word law provided under Article 13(2) would include a constitutional amendment, and therefore any constitutional amendment cannot violate or abridge the fundamental rights guaranteed under Part 3, and if it violated the fundamental rights, then to that extent the constitutional amendment could be declared to be ultra-virus by the Supreme Court. So therefore, by this judgment of L.C. Golaknath, the Supreme Court for the first time held in the year 1967 that the Parliament did not have the power to amend the Part 3 of the Constitution, that is fundamental rights, and the Supreme Court had the power to declare a constitutional amendment to be ultra-virus. Now, this was a major judgment of the Supreme Court at that time, and it clearly established the supremacy of the Supreme Court over the Parliament, because the government claimed that the Parliament had the supremacy over the Constitution as well as over the Supreme Court. Now, there was a clear battle between the Supreme Court and the Parliament. It is because of this judgment that 24th Constitutional Amendment came to be passed in the year 1971, which nullified the judgment of L.C. Golaknath by providing Article 13 Clause 4 and also inserting Article 368 Clause 3. Now, after the judgment of L.C. Golaknath, two important judgments of the Supreme Court were in the matter of R.C. Cooper as well as the Privy Purse judgment in the year 1971. Now, all these judgments have dealt in detail in my videos in the Constitutional Amendment Right to Property series. Now, after the judgment of the Supreme Court in the matter of R.C. Cooper and also the Privy Purse judgment, the Parliament enacted drastic constitutional amendments like the 24th Constitutional Amendment, 25th, 26th and 29th, thereby nullifying the judgments of the Supreme Court and also nullifying the judgment of the majority of 6:5 judges in the matter of L.C. Golaknath, and declaring that the Parliament's power to amend the Constitution is complete and it can amend any part of the Constitution. And it did away with the finding of the Supreme Court in the matter of L.C. Golaknath, wherein it said that it would not amend Part 3, as it inserted Article 13 Clause 4 in the Constitution, which provided that it would not apply to a constitutional amendment under Article 368. Now, 24th, 25th and 26th Constitutional Amendment nullified all the three judgments, that is L.C. Golaknath, R.C. Cooper and Privy Purse judgment. 29th Constitutional Amendment inserted the Kerala Land Reforms Act under the 9th schedule, and this was the cause for His Holiness Kesavanda Bharti to challenge the 29th Constitutional Amendment by preferring a petition before the Supreme Court under Article 32 of the Constitution. Now, the Kerala Land Reforms Act and the amendments which were inserted by the state legislature were declared to be ultra-virus by the Kerala High Court, and the said judgment of the Kerala High Court was upheld till the Supreme Court, and therefore the ultra-virus provisions of the Kerala Land Reforms Act, by placing it under the 9th schedule, were revalidated despite the judgment of the Supreme Court. Now, it is because of this that His Holiness preferred a petition before the Supreme Court challenging the 29th Constitutional Amendment. It is because of these constitutional amendments that the Supreme Court constituted a 13-judge bench decision to examine the correctness of the constitutional amendments as well as the law laid down in L.C. Golaknath. The Supreme Court in the landmark judgment of Kesavanda Bharti ultimately held that the L.C. Golaknath view was not correct and it overruled the judgment of L.C. Golaknath. It upheld the validity of 24th, 25th, 26th constitutional amendment except declaring Article 31C, the last part of Article 31C, to be unconstitutional. But this is how, due to several drastic constitutional amendments and several landmark judgments of the Supreme Court, which led to the 13-judge bench decision of the Supreme Court in the matter of Kesavanda Bharti versus Union of India. Now, all these judgments, I have dealt it in detail in my earlier videos in this constitutional law and right to property lecture series. It is after Kesavanda Bharti judgment that in the year 1978, by way of the 44th constitutional amendment, the right to property came to be deleted from the fundamental rights. I hope you like these videos. Thank you for watching.